In this episode, we will review 3 different probable cause hearings held in the courtroom of Judge David Fleischer of the Harris County Criminal Court in Houston, Texas. A probable cause hearing is a proceeding that takes place soon after a person has been arrested, especially when the arrest was made without a warrant. Under Article 15:17 of the Texas Code of Criminal Procedure, the arrested individual must be taken before a judge without unnecessary delay. At this appearance, the judge informs the defendant of their rights and reviews the facts presented by law enforcement to determine whether there is probable cause to believe that the individual committed the offense. If the judge finds that probable cause did not exist for the arrest, the defendant must be released. Our first probable cause hearing took place on November 4, 2024, after defendant Raquel Rodriguez was charged with driving while intoxicated on October 28, 2024.
Okay, Max, who do you have here?
Raquel Rodriguez.
Rodriguez. Vic, you ready? Okay, this is page 20.
On page 25.
All right, Ms. Rodriguez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and/or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge.
Okay.
The officer initiated a traffic stop after observing the defendant's vehicle traveling 94 miles per hour in a 65-mile-per-hour zone. The officer observed an odor of an alcoholic beverage, and the defendant admitted to the officer that she had 2 drinks. Standard field sobriety tests were conducted, HGN 4 out of 6, walk and turn 5 out of 8, one leg stand 2 out of 4. The DIC was read and breath was refused. A blood search warrant was signed and executed.
Felt like that went really fast. So the stop was for speeding.
For speeding, yes.
Then
And then after that, they had an odor of an alcoholic beverage, and she made an admission that she drank 2 beverages.
just an odor and admission of 2 beers. Any other indication of intoxication? I mean, slurred speech, bloodshot eyes.
I know that while the SFSTs were, this is for the Jams, while the SFSTs were being conducted, she was not understanding, like the officer had to explain, I think at least 4 times, the instructions for the walk and turn, the 1 leg stand. He also noticed that I think she took off her boots for the 1 leg stand. She was stumbling when she was taking them off. So there were other signs that the officer.
That's what I want. I mean, an odor, not even a strong odor at that, you know? And then you just have an admission of 2 beers. You don't know what time. Was it over a 12-hour span? You know, there's no accident here. There's no, is she a Spanish speaker?
I believe so, Your Honor.
I don't see any indication of that.
And if I may, I've been doing DWIs for 10 years and I don't understand the instructions most of the time.
As far as I can tell, the officer also just demonstrated it to her, I mean, which is per, you know.
But I get the SFSTs, but I mean, to even get to the SFSTs, right? You have to show something that there's some indicia of intoxication. Here, all we have is an odor and admission of 2 beers. That's not enough. An odor of alcohol in and of itself is insufficient.
Yeah.
It seems that this stop occurred at 2 in the morning, and she made a statement that she stopped drinking at 12 a.m. So we have a 2-hour period between when she's finished drinking and then
alcohol dissipates every 1 hour. An alcoholic drink dissipates from your system.
She still had the odor in addition to that statement.
All right, I'm going to find no probable cause.
Yes, Judge.
Ma'am, be careful, you know, really. Every single day, someone dies from a DWI in our county. It's so easy to take a $20 Uber, literally push 1 button. You have a car waiting for you wherever you want to go in this county. Do you understand?
Yes, sir.
All right, please take a seat.
Judge Fleischer finds no probable cause for the charge because he did not believe there were sufficient indicia of intoxication to authorize so-called SFSTs or standard field sobriety testing. Because field sobriety testing extends the duration of a traffic stop, resulting in a longer investigative detention, officers must have reasonable suspicion that a driver has committed an intoxication offense in order to require field sobriety testing. Here, the evidence was limited to the smell of alcohol and Ms. Rodriguez's statement that she had consumed 2 drinks, the last of which she had finished 2 hours before driving. Accordingly, Judge Fleischer determined that there was no reasonable suspicion to extend the traffic stop to perform field sobriety testing under state and federal case law, as well as Article 38. 23 of the Texas Code of Criminal Procedure. Evidence that a police officer obtains through a constitutional violation, such as extending a traffic stop without reasonable suspicion, cannot be admitted into evidence against the accused in a criminal case. Therefore, because the results of the field sobriety testing could not be considered, Judge Fleischer concluded that there was no probable cause for the arrest, and the state eventually dismissed the charge on February 24, 2025. The next probable cause hearing we will review also occurred on November 4, 2024. Defendant Kian Shaw was charged on October 28, 2024 with fleeing a police officer in violation of Section 545, 421 of the Texas Transportation Code, which makes it a misdemeanor offense for a driver to willfully fail or refuse to bring their vehicle to a stop when given a visual or audible signal by a pursuing police vehicle.
You are Keon Shaw.
Yes, sir.
Mr. Shaw, you're charged with fleeing a police officer. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Yes, Judge. On October 27, 2024, officer was conducting a routine patrol on Eldridge Parkway when he noticed the defendant's motor vehicle traveling at an unsafe speed, exceeding the posted 35-mile-per-hour zone. The vehicle then began driving in a suspicious manner by making a sudden left turn on the street and immediately parking on the left side of the road. When the vehicle noticed the officer's fully marked patrol vehicle passing, it immediately conducted a U-turn and got back on the main road. When officer continued to follow the defendant's vehicle, the vehicle again conducted a left turn and pulled into an alleyway. When the officer initiated his emergency equipment in an attempt to conduct a traffic stop, the defendant's motor vehicle passed multiple safe stopping points before finally coming to a stop after traveling 0.5 miles through a dark and empty parking lot.
What was he doing wrong?
According to the officer, he was originally traveling at an unsafe speed, exceeding the speed limit, 35 miles. He was exceeding that speed limit.
By how much?
Let me see the DMs if he specified. Your Honor, he did not specify. It was just an unsafe speed exceeding the limit. And then
Nothing's unsafe to me.
And then he began driving, according to the officer, in a suspicious manner, making sudden turns and then stopping on the side of the road and then getting back on the road once the officer passed. So
Anything illegal with that? You
Your
know,
Honor, I believe it would just be the speed limit would be the point at which the officer.
it's a conclusory statement. We need to have like a workshop on how to write ORs, man, for real. You know, everything in this office report is conclusory, suspicious, aloysius. You know, is he driving while black?
Judge, would you allow us just a few minutes to call the officer just to see? We don't have an OR. We're just going off of the.
Sure,
DMs.
let's do this. I'm gonna have them because I want to make sure if we find probable cause that it's really there. All right, so just hang tight for me. We're gonna have to do a little deeper dive. If you just mind taking a seat for me momentarily, okay? Okay. Okay, so Mr. Shaw, we're back on you. So just because we do so much, I tend to forget everything, you know. You're charged with fleeing a police officer. You're facing up to 6 months in jail and a $2,000 fine. We left off because we were doing probable cause, and I had an issue because it seemed like the cause was kind of conclusory at the time. And do you have anything new?
No, Judge, and I agree with the court.
So, okay, I'm gonna find no probable cause.
Dismissing the case.
Find no probable cause. Be careful when you're out there. It's hard enough as it is. Don't give anyone else the power to even bring more, trouble on your life, all right?
Yes, sir.
All right, man, good luck.
Judge Fleischer finds no probable cause based on the fact that there was no specific allegation of how fast the driver was going in order to justify the stop in the first place. Although the Texas Transportation Code does not specifically require the stop itself to be lawful in order to charge someone with fleeing, the Constitution still applies. If the stop violated the Fourth Amendment or Texas law, then as we discussed earlier in this episode, Article 38, 2323 of the Texas Code of Criminal Procedure requires that any evidence from it, including the officer's account of the driver not stopping, cannot be admitted in court. Under the Fourth Amendment, an officer may not stop a vehicle without reasonable suspicion based on specific and articulable facts that a traffic offense or other crime has occurred. In the 2005 case of Ford versus State, the Court of Criminal Appeals of Texas rejected a stop where the officer claimed that the driver was following another vehicle too closely without describing the actual distance between the vehicles, determining that a mere conclusory statement that a law was violated was not specific enough to provide reasonable suspicion. Accordingly, Judge Fleischer found that there were insufficient, specific, and articulable facts to find reasonable suspicion and therefore that there was not probable cause to support the arrest based on the admissible evidence. The state dismissed the charge that same day. The final probable cause hearing in today's episode took place on January 27, 2025. Defendant Francisco Cerda was charged on January 22, 2025 with engaging in organized criminal activity in violation of Section 71.0202 of the Texas Penal Code. This statute makes it a crime to commit or conspire to commit certain offenses with the intent to establish, maintain, or participate in what the statute calls a quote-unquote combination, which Section 71.01 of the Penal Code defines as 3 or more individuals collaborating in carrying on criminal activities. The statute applies to a wide range of offenses, including drug dealing, robbery, burglary, assault, murder, money laundering, and as in Mr. Serra's case, theft.
The last one, Your Honor, is Mr. Francisco Cerda. He's a custody judge, and I wanted to touch on wrong offenses.
Is that C or an S?
The C judge, okay.
Good morning, Mr. Cerda. You are charged with engaging in organized criminal activity. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
Yes, Judge. On January 21st, 2025, the officer was dispatched to a residence in Harris County, Texas. In the call notes from dispatch state, the reportee says an unknown party stole her neighbor's U-Haul trailer. Subjects were seen headed towards Pasadena Boulevard. The driver was a skinny, tall male, and the reportee lives on Buchanan Street and has camera footage of it happening. A witness stated he observed individuals taking the neighbor's U-Haul. The officers located the U-Haul and a felony stop was conducted. Defendant Hentoja was observed unloading items from the U-Haul, ran to the back of the residence, and prevented officers from arresting him. Defendants Lopez and Cerda remained in the U-Haul, and the complainant stated the value of the trailer was $1,800 and dirt on the trailer was $300.
I have so many questions.
Yes,
I
Judge.
don't even know where to start.
My concern is, if you may, I want to bring some, I guess, some points of argument to the court's attention. The first one, my concern is that, the 911 caller mentioned unknown parties, and then the police officer later mentions them as suspects without any type of articulable facts, believe that they are the specific people or the individuals that have taken this U-Haul. Now, as we know, probable cause requires more than a hunch, more than suspicion. It requires something else, more than that. And that seems that that's all that the things, at least under the 4 corners of the things, allege that my client was involved with this alleged theft.
Remember, so when they start an investigation, sometimes they just don't have everything and facts develop in time.
Right.
Here, we have a call that several people have stolen a U-Haul.
Yes, Judge.
And they've given a description of a tall, lanky person,
Yes.
right?
Yes, Judge. And respectfully, we defer to the court because all it says in the DIMS is that the defendant Cerda remained in the U-Haul. There's no further information regarding Cerda.
Where was he in the U-Haul? Was he in the actual U-Haul? Was he in the truck that was driving the U-Haul? How was he engaged in this alleged criminality?
And Your Honor,
can you does mere presence impute criminality?
Judge, and that's exactly right. Texas law says that mere presence is not enough.
Dude,
to bring trouble.
I'm with you.
Oh, yes, sir.
But so
we're not arguing against that, Your Honor. And like I said, we defer to the court because we don't have that information. We have to await the OR, and we don't have that at this time.
but I'm not going to sit here and hold
Judge.
someone.
And that's why we defer to the court.
Let's look at what the statute says, because 7102. A person commits an offense if with intent to establish, maintain, or participate in any combination or in the profits of a combination or as a member of a criminal street gang, the person commits or conspires to commit one or more of the following. 1 is murder, capital murder, arson, yada, yada, yada. 2, any gambling offense punishable by a Class A misdemeanor. Promotion of prostitution. Number 4, unlawful manufacture, transportation, firearms. Which one are you relying on?
Your Honor, as it's pled is that it's pled as theft as being the underlying basis of the engaging in criminal activity. And right now, Kelsey is looking at the case. We may very well dismiss this because of the insufficient evidence in the information in the DIMS, but right now, Chief is looking at it.
And Your Honor, if we could just maybe reset it for a week or so, we call the witness. and we have to
No,
decide.
he's in custody, and I can't, I mean, if he was on bond, that would be one thing, but he's in custody. I'm not gonna hold him just because, compounding it, Casey, is that he's got an ICE hold, so I can't give him a PR bond,
I just need a little more time, Your Honor, to dismiss it right now.
Yeah, I'll find no PC because I just don't think it's there for now. And then if you find something later on, by all means, but all right, Mr. Sird, I'm going to find that there's no probable cause to go forward in your case. Just, Mr. Serta, be careful who you hang out with, Okay, all right, for sure.
Judge Fleischer finds no probable cause because there were no specific allegations regarding Mr. Sid's conduct besides being present in the stolen U-Haul. As the Court of Appeals of Texas in Amarillo explained in the 2000 case of Munoz versus State, in order to be convicted of engaging in organized criminal activity, the defendant must intend to participate in, maintain, or establish a group that agrees to work together in a continuing course of criminal activity that encompasses more than one crime or criminal episode. The court also held that an individual's presence during a single episode of criminal activity was insufficient to prove any agreement to jointly engage in illegality over the course of time. In Mr. Sida's case, it was only alleged that he was in the stolen U-Haul with no evidence supporting his potential involvement in more than one criminal episode or that the three defendants had an agreement to act together in a continuing course of criminal activity. Consequently, Judge Fleischer found that there was no probable cause and the state dismissed the charge against Mr. Sarita on February 24, 2025. These hearings underscore why probable cause determinations are such a vital safeguard in our justice system. When someone is arrested without a warrant, they are immediately deprived of their freedom, potentially based only on an officer's word. The probable cause hearing is often the first meaningful opportunity to test whether that arrest was truly supported by evidence that can withstand judicial scrutiny. Judges like Judge Fleischer, who carefully examine the evidence rather than simply rubber stamp the arrest, help ensure that constitutional protections are meaningful in practice and reinforce the principle that government power must be checked. When judges find that an arrest was conducted without probable cause, they not only protect the individual accused, but also strengthen public confidence in the court's commitment to fairness and impartiality. Let us know if there's a case or courtroom interaction that you'd like us to cover in the comments below. Thank you for watching, and don't forget to subscribe and share so that we can foster a more informed society.